Good afternoon, Facebook. Good afternoon to everybody who's watching. Thank you for joining us as we elevate dreams, establish brands, and expand legacies. Today, we're focused on your legacy. I am attorney Lorraine Birabil.
And I'm Elan Moore Jones.
And together
we are
Elaine Law.
So what we do, we are intellectual property lawyers. We specialize in copyrights and trademarks, as well as business law. We do formations, contracts, your basic business full package. We also specialize in estate planning, which may include wills and trusts, as well as your ancillary documents, such as your powers of attorneys. So that's what we're here to discuss today.
And who we serve. We serve creatives, entrepreneurs, and literally anyone who owns anything. That could be a breadwinner, that could be an heir, that could be someone who owns mineral rights. If you're a parent or a grandparent or even a great grandparent, you may not even know what you will ultimately end up inheriting. For example, people remember, the situation with the Marvin Gaye estate. And the intellectual property rights and the royalties from that. When we think about asbestos cases, a lot of times, unfortunately, people pass and they may not know that the reason why they passed was due to the neglectful, wrongful acts of someone else. And so the people who stand to inherit from the loss of the loved one and who have had to bear that emotional loss may also have a financial benefit to gain from the way that their loved one was lost from a lawsuit, settlement, things of that nature. So pretty much, if you are a person and you own literally anything, even if it's a Greek letter jacket from undergrad, baseball cards that you've been collecting, you might have a Hank Aaron card in there. It could be valuable, and so you need to have an estate plan.
Exactly. So how to get in touch with us? We are online at www.elainelawgroup.com. We're also able to be contacted via email, which is legal@elainelawgroup.com, and by phone at 214-432-3113. We're also on all the social media platforms, the major social media platforms, including Facebook and Twitter. We are at Elaine Law Group. On IG, we are at the Elaine Law Group. So please don't forget to also register today at our link that will be provided in the chat there for you. If you want to receive our free legacy checklist, that'll be sent out to all participants, or all who sign up for the checklist will receive that. It's basically like your legacy playbook. We also are able to book consultations through our consultation link, which will also be provided in the chat as well. Just as a disclaimer for today's one-on-one presentation, the information we're providing is for informational purposes only, and it is not fully comprehensive. All estate planning should be executed by an attorney in your respective state. If you're not in the state of Texas, we are Texas attorneys licensed to practice here, but you will need to find and locate a licensed attorney that is barred in your state where you reside.
Thank you so much, Elan. So now that we've gotten, the introductions out of the way, how you can connect with us, I think we want to get to the bulk of the workshop that we're having today, which is about estate planning. So let's go ahead and dive right in. So let's start off with what is an estate plan? Sometimes that is a question that we get. We don't expect you to go through 3 years of law school to figure that out, and that's what we're here for. So an estate plan is basically a set of documents that govern how you want your property to be disposed of in the event that you are no longer on this planet. And what we know is that all of us, it's not really a question of if, it's more of a question of when. And so it's a process that designates how your assets will be distributed upon your passing. And it can also ensure that your beneficiaries receive the assets in a way that maximizes, or should say, maximizes the opportunity to recover the most, meaning minimize taxes and other expenses, ideally. And we talked about this a little bit earlier, but I want to go a little bit deeper into this, why you need an estate plan. Like we said, if you own anything, you need an estate plan. Some things that you should be thinking about in preparing an estate plan, think about what you own, both tangible and intangible. We alluded to this earlier. You might own real property. You may have personal effects like sports memorabilia, what have you, that are tangible. Those are considered property that can be dispersed. Intangible assets, that could be intellectual property, for example, any copyrights, patents, or trademarks that you either hold or have rights to. Those are considered intangible assets many times. Think about what your loved ones need. Sometimes people think, well, I don't have, and I don't really own much, so I don't need an estate plan. But some of the things that we talk to people about when they do prepare an estate plan, do you have insurance, life insurance, I should say? And do you have enough coverage? That is something you really need to think about. Also, regardless of whether you believe you have assets or not, if you're the guardian of a child or a grandchild, having an estate plan is important because you can designate who the guardian will be of your child or your grandchild in the event of your passing, if you have custody of that child, and how you want that dependent to be cared for. You may have very specific needs that you feel like need to be met for this dependent. Maybe you have some ideas on how you want any assets to be used to pay for their college education, for example. Those are all things that you can outline in your estate plan. It also establishes directives through your estate plan. So let's say, for example, and my law partner is going to bring this up later, but Elan is going to describe, for example, some directives you can provide your doctors and to loved ones if in the event you become incapacitated and no longer can make medical decisions for yourself. Review the beneficiaries on your probate and non-probate assets. And my law partner will talk about the difference between probate and non-probate assets later, but just want to put that out there for now. And also, when you do come up with an estate plan, just because you came up with it does not mean that you never need to revisit it. There are going to be life changes. Everyone in the course of being human and being human and living on this earth, we all experience things that change our life circumstances, whether that is getting married or having a child, or maybe adopting a child, or maybe you're an aunt or an uncle, and unfortunately a loved one passes and you're now caring for your niece or your nephew, right? These would all be considered life changes. Purchasing a home, perhaps at the time you draft your estate plan, you didn't have your home in there, and so you need to update that. Or in the event that your family transitions and you get a divorce. These are all reasons why you would need to update an estate plan. So just because you get it done now doesn't mean that at some point, if there's not a major life change, that you don't need to revisit that. And types of documents that can be included in an estate plan. A lot of people have heard of wills. Obviously, a will is part of an estate plan. Depending on your circumstance, it might make sense to have a trust. My law partner, Elan, will talk more about the trust later. Medical and financial power of attorney. These are documents that designate who is to make decisions on your behalf, whether it's a medical situation or if it's a financial management that's needed. Directive to physicians, family, and surrogates. That's basically an advance directive. If you are on life support or you're incapacitated for some reason, it does give direction to your family. The last thing that you want your loved ones arguing about and fighting about if something comes to happen to you that incapacitates you or you're in a coma, the last thing you want is your loved ones fighting over how you will be cared for. And so that is one way you can make your wishes known. That would include a HIPAA release. HIPAA is a law that basically says that your medical information cannot be shared without your authorization. You want to make sure that you have that so that your loved ones can make informed decisions as well. Declaration of guardian. If the event you become incapacitated and you need a guardian, who do you want that to be? If you have your estate plan set up, you can choose who that person would be rather than a court making that decision for you. And lastly, supported decision-making agreement. This document can be very helpful if you are still in a position to make decisions, but you need help in that process. And we'll take some time to talk more in detail about that later. So the first document that we mentioned was a will. It's a legal document that expresses your wishes regarding how you want your property distributed upon your passing. And like we mentioned, designates who will manage the property until it's distributed. That is called an executor. In Texas, one of the really unique things we have in Texas is you can have a holographic will. A holographic will means that you can literally handwrite your will out in your own penmanship, as long as there's no other pre-printed text, like typewritten or computer printed, computer generated. If it's all handwritten, then technically you don't have to have a witness. And if you've signed it and it meets all the other legal requirements, that handwritten will in your own handwriting will be considered valid for a probate court. So with that, I want to go ahead and transition to Elan, who is going to discuss trust, which is an item we get a lot of questions about.
So trust. Trust have recently become very trendy in a lot of people's requests for estate planning due to YouTube. You might have some financial advisors that are recommending it. You may also have read a few articles or things of the nature that advise for a trust. A trust is available as an estate planning option, but it is not the only option. As Lorraine alluded to, a will is also wonderful, and it does everything to execute your wishes upon your passing. But for many of our clients that are very passionate about wanting a trust, because the major reason is to avoid probate and to basically, it's kind of like as I was taught, it's like a pre-probating of your estate. So you put everything into a trust. It allows you to, in your lifetime, designate your property that you want to go into that trust. And it also allows you to, as stated, avoid probate in certain instances, which is what Lorraine was alluding to. You want to make sure that you're constantly updating that document, that no other documents could possibly override the trust or the things that are put into the trust. And you want to make sure that it's something that's managed properly and is actually funded. It also assists in preserving privacy of the individuals. A lot of people with a substantial estate don't want their probated items to be made public. So it assists in preserving any privacy because it's not then put on the public probate registry as a will would be. It also offers you an asset if you're ever incapacitated, because it's held in that trust, and the trustee is the person that maintains and makes distributions from the trust, and it could be in your benefit upon incapacitation. Lorraine, are we getting questions? Okay. So some advantages, there's the two standard types of trust in the state of Texas are the revocable and the irrevocable trust. Revocable is often also called a living trust or inter vivos, which means in your lifetime. The advantages each have their own advantages and disadvantages. But some of the basic highlights, because this is 101, I won't go too far into the woods here. One of the main advantages for revocable is that you are able to maintain control, as in you can be one of the initial trustees as the individual putting those items into the trust. And then upon your passing, you can have an alternative trustee who would take over or settle the trust on your behalf. But you're able to maintain control of those assets, even though they are signed over into the trust. for the funding purposes, but you're able to maintain that control during your lifetime. It can also be modified. Now that's for the revocable. For irrevocable, it does add a little bit of tax benefits and protections from creditors. When you're thinking about a trust in general, you want to make sure that you have a tax planner or an accountant also working with you on these items, or an attorney that if you have a substantial estate, if it's more than, I'm sorry, I'm drawing a blank, but if it's more than a substantial number, we would have to advise that you speak with a tax attorney on certain aspects of the estate tax issues. Some disadvantages of the revocable is that there's not any real tax benefits on the revocable, and there's no firm protection from creditors in the revocable. The irrevocable is hard to relinquish control. I'm sorry, it's hard to maintain control because you are relinquishing control. A lot of people have to understand that you're now giving that control over to the trust. It's not flexible at all. And you're at the mercy of the trustees. They can oftentimes be very complex documents that even the individual creating the trust can't understand. So you want to make sure that when you're entering into something called an irrevocable trust, you want to make sure that with your attorney, making sure that it is something that you'll be able to understand why you're creating it and what you're funding it with, and why and how it's actually executed as a legal document. So yeah, and it also, the irrevocable trust wouldn't be able to be modified unless all of the beneficiaries of that trust agree to any modifications. So that's something to consider. So I'll jump into now the powers of attorneys if we don't have any questions, Lorraine. No questions yet?
We did have a question about power of attorney. So I think
we're going into power of attorney.
We're right into that. And as soon as we're done with that topic area, then we'll get to Ms. Contreras's question.
Okay. Yeah. So we have several powers of attorneys that are usually included in the standard estate plan in Texas. We start with the medical power of attorney that allows someone to be designated as your agent in the event of any medical needs. They're also able to make medical decisions if you become incapacitated. So you kind of want to make sure there's someone you trust with your life, and you've expressed your wishes clearly to them before appointing them as your medical power of attorney. That's also a document. All of these documents are ones that you want to constantly go to and reevaluate if the person has died that you may have appointed as your agent, or if that person is no longer capacitated themselves. Maybe they had a mental breakdown. Maybe they have shown you, as they say, their true colors, and you don't want them to make decisions for you. If this isn't a spouse, you want to make sure that you're updating that periodically and revisiting those documents as the time arises. The next one is what we call the durable power of attorney. It's also the financial leg of the person. So each person has financial powers, then you have medical powers, or powers over the person themselves. So that's how the person would include, like your doctor, your medical decisions, where you're living. That's the person. What you're eating, that would be considered the person. This is called the durable power of attorney. It's for your finances. So this allows someone to be designated as your agent to manage your financial affairs in the event you are medically unable to do so yourself. So this is the person that ideally is good with finances, has no excessive outstanding debts of their own, where they will, dabble into your finances if they get into a bind. So this is someone that you, obviously all these people are someone that you trust highly, but this should be someone that has some financial savvy about themselves. Preferably no one that has been in prison for forgery or
Crime and moral
anything like that.
turpitude.
Yeah, moral turpitude. I was gonna throw that one out there with you. So the next one would be another medical document. This is the directive to physicians, your family, and surrogates. It also includes your HIPAA release. It's also called it's an advanced directive or your HIPAA release are two different things, but those two documents are legal documents that specify instructions for your care if you're ever like incapacitated or on a they call life support, right? You're ever on life support where you're no longer able to make any kind of decisions. If you are in a coma, not lucid at all, this is the person that you would appoint in your HIPAA release, as well as what you would outline in your advanced directive to your physicians. This is what I want. I want to be on life support. I don't want to be on life support, things of that nature. It allows the medical staff to release information. That's the HIPAA. HIPAA is federal, and those individuals are held to the federal standard under the HIPAA form. So that's the person that you're able to release, that the doctors, are able to release any medical information to in regards to your health or your condition. It also provides, the advanced directive provides a comprehensive instruction on how your care should be executed. And so we'll move on to the declaration of a guardian. Lorraine.
Before we transition to that, I want to make sure we get to Ms. Contreras' question. She asked, are got a little tongue tied here, power of attorneys filled by the state or require an attorney to file in some official capacity? Or can you use a generic form online and file it in your personal effects and take it out when you need it? Alon?
Yeah, so depending upon your state, we can speak specifically to the state of Texas. In the state of Texas, there are some statutory documents. That's why it's called a statutory durable power of attorney that are required, that certain items are outlined within that based off of the statute. That's what the legislators have designated to be included in the statutory durable power of attorney within the state of Texas. Online documents, if you're in, of course, we're lawyers, we don't recommend online documents at all. As stated before, we highly suggest or advise that you at least have the counsel of an attorney to review your documents or create your documents for you. That way, they're ensuring that all of your state-specific clauses are included, that you fully understand what you are executing. And they're also attorneys such as ourselves are able to judge your capacity in creating those documents. In every contract or every document that you sign, capacity is at issue, meaning that you shouldn't be under duress. Like no one should be forcing you to execute the document or make them your power of attorney. No one should be coercing you or bribing you to do so, or extorting you to do so. They have some dirt on you, so you better hurry up and make them your financial power of attorney. If you're already incapacitated, if you're executing a document online or having your grandmother execute a document that you found online, and she's maybe has pre-Alzheimer's, or she has dementia, pre-dementia, or full-blown dementia, executing that document at that time will be problematic, and any individual accepting that as the official document will be held liable for anything, or there would be it would be questioned later on, should any ethical issues arise as far as capacity. So attorneys are able to judge capacity. We're able to explain and execute the documents fully to your understanding. And we're also able to include all state-specific items. So I wouldn't recommend doing anything online. I would recommend finding or seeking out the attorney that you trust in your state, if not us, in your state. And yeah, so.
And might I add, just in general, we hear clients who come to us all the time after the fact. They've drafted some contract that they found, like I say, on Google University or YouTube grad school. And sometimes, the clauses, sometimes it's missing important clauses. It's not really customized to your specific situation to add in all the protections that you need. And the same thing applies in the estate planning space. When you come to an attorney, you may have very specific needs, such as someone to designate to take care of a dependent, or a specific way you want things handled. Or even some of our clients have said, I want my funeral arrangements handled a certain way. Obviously, you could work with a funeral director and get a pre-need document done, but you can also include your wishes in as part of your estate plan. So there is a benefit, obviously, to going to a professional who can customize based on your situation and what your needs are, to make sure that hopefully your wishes are carried out to your intent. And courts typically do give deference to a legally executed estate plan, will, trust, what have you, whatever the instrument that is being referenced, as long as it is properly executed in terms of all the statutory requirements, the courts do give effect to that. So
the other thing I would add to that, Lorraine, you made me think about it, is a lot of people come in thinking they know exactly what they need. But truthfully speaking, once an attorney is able to assess what your needs are, review your bounty, which would be all of the things in your estate, all the things that you own, have a better gauge, or better able to actually say, this is actually what you need. This is how it should be outlined in the plan. And a lot of times when you're on YouTube University or Google Scholar, you are missing the bigger picture. So, which is why, we do what we do.
Absolutely. When clients come to us, we actually undergo a full review of as my partner said, your bounty, every asset. We provide you a checklist. So you may not even be thinking about some things that are actually legally considered assets. And so definitely, want to speak with a professional. That is definitely ideal for sure, to make sure all your I's are dotted and your T's are crossed. Okay, so I want to now transition to some of the documents we talked about towards the beginning. We're kind of towards the tail end here in terms of the full service estate plan, a declaration of guardian. Sometimes people aren't thinking about this, and Elan alluded to this earlier. If the event happens that you become incapacitated, you or need a guardian, you want to be able to choose who that person is while you still have capacity to make the decision. And this is the case with a lot of things in Texas law. If you do not designate it in writing in a legally cognizable document, the code will determine for you, or a court will determine for you. And I'm pretty sure that that the state does not know you better than yourself. The state code that the legislature has drafted does not know you better than you know yourself, or the loved ones in your life, whether they are friends or family, or if they're or friends that you choose to be family. Definitely none of those public entities know those people in your life like you do, to know who would be the best person. And it may even be the case that there's someone that you're going to choose because that your values align, that perhaps the decision that you would like to be made if you're on life support is a similar decision that they would make for themselves, right? These are all things that will go into your decision-making process in terms of who that would be. But again, if you are incapacitated, you want to be able to choose who's going to make those decisions for you. If you need a guardian, who is going to be that guardian on your behalf? You don't want a third party choosing that if you can avoid it. And finally, one of the last documents that I want to talk about being included in your state plan is the supported decision-making agreement. So basically what this allows you to do is, let's say you have a disability, you still have capacity, but you have some sort of disability that is impacting you. Well, this allows you to maintain your capacity and still make decisions for yourself despite the disability if you have the aid of a trusted person. This is a document that Texas courts are also recognizing because everyone remembers probably the whole Britney Spears situation and the situation with her having a conservator. And so as an adult who was a professional entertainer, she herself was subject to not being able to control and make decisions for her own affairs. And so, not that her situation is similar to what we're discussing here in this document, but I bring that up as an example that if for some reason, if you do have some sort of disability or some event that has caused you to be disabled for a particular period of time, or whether that is a permanent disability, it still allows you to maintain that autonomy with the aid of a trusted person. And I think every person who's watching this, if they have the opportunity to make decisions for themselves and have capacity to do so, they want to be able to continue to do that. And the legal trend is definitely moving away from guardianship and more toward this sort of supported decision-making opportunity if it's available to do so. And so by you having that document in your state plan, you're giving yourself even more reason to have that recognized by a court rather than someone else making those decisions for you. So at this point, I think it's prudent to transition to probate, because a lot of times people confuse probate and estate planning. And so, Ilan, if you can take that away and explain to the community here, what exactly is probate and how that relates to estate planning.
So probate is a process by which the court legally recognizes the death of the individual and who's able to oversee the estate. That's the individual that's able to make payments from the estate's accounts, anybody that's able to clear any debts and make distributions from the executor, to make distributions from the decedent's will. So that person is considered what's called the executor. The probate process can declare who's the executor based off of the will that is written. That process could go either way. There are several different types of things or instruments that probate estates. It could be a monument, a title, small estate, affidavit, or just the simple probating of a legally executed will. So there are multiple ways. We won't go into those woods, but there are several different reasons that you may have to file different applications to be entered into probate, based off of what the estate looks like, whether or not you have a copy of the will, whether or not you have the original will. Back to the will statement. Once your will is fully executed by your attorney, please secure a original copy of the will and let your heirs know where the will is located. We all are going to experience a time when our loved ones die, and the worst thing that can happen is you not know where the wills are, or not know what kind of estate planning, if any, was executed. But as soon as you execute any kind of estate plans, you should let people know, you're my executor, you're my agent. Let them know up front. The last thing you want your family to be doing is arguing over who's supposed to be the executor. You don't want your sister finding out that, she's not the executor, instead it's your mom's best friend, right? People get hurt, feelings get hurt, and things don't get done when that happens. And that's not helpful. So that's my little soapbox. I'm off script there, but it is imperative. It is imperative that you explain and have these conversations with your loved ones. We have to demystify and get rid of that stigma within our communities. And I'm speaking specifically to our minority communities, where we do not discuss what happens with our estate once we die. We have to have these conversations, hence the reason we are doing this line of work. Not everything goes through not everything goes through probate that's within the estate. Things that do not pass through probate include life insurance policies. So these are all things that are contractually based. A contract that you made with a third party, which would be your life insurance. Your life insurance is through Allstate or USAA or MetLife, right? That's the agreement that you made with them. Those beneficiaries, for the most part, will be reflective of your beneficiaries in your will. But if you don't go and update things periodically as you should, sometimes it may be, they may vary. You always want to make sure that you have beneficiaries listed on all insurance policies. Retirement accounts, your beneficiaries should be listed there. And those things will be distributed based off of what's in that contract. Who did you appoint as your beneficiary? You want to have pay on death accounts. Those are outside of probate. Any trusts, fully funded trust, I should say. Any fully funded trust would pass outside of probate. Joint tenancies, that share property with right of survivorship. Someone else has the right to the property if they survive you. Intervivals gifts, things that you gift out within your lifetime that you've given away. You might have had a car in your will, but you gave that car away during your lifetime to your little cousin who needed a car really, really badly at the time, but you didn't update that in your will. Well, that car is no longer a part of the estate because you've given it away during your lifetime. As well as small estates, sometimes those may still require a court order, but they're able to be executed outside of the full probate process. The last thing that I would say on this point of probate in general is the probate process in Texas is pretty swift. However, there are very particulars about individual things such as a copy of a will or things weren't, clients aren't upfront with their attorneys about what's happening. All things do happen. COVID, pandemic, right? How pandemic slows down the system. So you just have to be considerate of everything that's going on that might slow the probate process. So. And then any questions, Lorraine? Pop up now?
So checking on there, I just want to remind people who are watching, you can get your questions in now. We typically do charge for consultations. So if you get your question in now, it is free 99. So feel free to chime in here on the chat and ask your questions. I also received some text messages, so we'll go ahead and put this text message question out here. Oh, someone asked if they have someone in their life that they love and care for that is special needs. What factor does that role? What factor would that have in creating an estate plan?
That's your guardianships, right? You want to make sure that that person has a guardian. You might even adopt that person through the adoption. You can adopt an adult in the state. Of course, that's more along the family law side. We don't have a family law, but those things can happen. But guardianship is usually the way to go with with any individuals experiencing special needs within a family.
And I definitely want to add, as we talk about implications in terms of tax and what have you, special needs trust, depending on your situation, obviously talk to an attorney. We'd love to be your attorney. But special needs trust is something to also be considered in addition to guardianship. Obviously, you want to make sure the person making decisions on that person's behalf is the person that you wish it to be because you trust them. But also with the special needs trust, it allows that person who does have that special need to continue to get the government support that they should be entitled to. So for example, Medicaid, for example, a lot of times people who have special needs rely on that in order to have healthcare access. And in some cases, would not be able to afford private insurance because of their situation, or because they may not even earn enough, or you may not even earn enough to pay for those medical costs out of pocket, right? So when we think about us caring for someone that has special needs, these are definitely factors that we need to look at, and perhaps a special needs trust, depending on this person's situation, might be something to look at as well.
And before you put them in your will as a beneficiary, you need to consider that. Excuse me. You need to consider the amount that person would be inheriting, the value, because that can also interfere with their ability to receive those government benefits that they may be receiving at the time of your death or before death. And so that can impede or hinder their ability to continue to receive those benefits.
Okay, and we have here Ms. Contreras responded, super helpful, thank you. Missy A. Jones, great information. So looks like we're getting really good feedback. I want to go ahead and take this opportunity to give people another chance to get their last minute questions in. While we're doing that, I just want to make sure everybody knows how to reach us. If you are looking for either Elan or myself, Lorraine, we together are Elaine Law Group. If you have questions or would like to schedule a consultation, we can be reached online at elainelawgroup.com or by telephone at 214-432-3113. I might add, this is a question we get sometimes. Any fees that are paid during the consultation are actually applied to the services rendered. So if you feel like I want to find out first what I need and then come back later, that consultation would still be applied towards the services rendered. So the funds are not lost. And even if you don't decide to engage an attorney, at least you have the basic understanding and information you need to make an informed decision for the people you care about or the causes you care about. You may decide that you want your estate to go to a charity that's near and dear to your heart. So doing this process would make sure that happens. In the event that you pass without an estate plan, intestacy in the state of Texas would apply, which means instead of, let's say, if you had an endowment you were trying to set up at your university, for example, instead of it going to that endowment that you would like for scholarship opportunities for students or what have you, that means that it would go to the next of kin. You may not if your closest to kin is a distant cousin that you've never met before, under Texas law, that's what would happen without you having an estate plan. So, or a relative who's not so distant, but that is not your preference, right? And so these are things that are very, very important to consider with all of this. But again, I want to thank everybody so much for joining us. If you signed up for the free legacy checklist, we alluded to some information that is in that checklist in terms of how you can prepare to keep your family not fighting over anything after you're gone. And the last thing you want them to do in your absence is they're already going through enough pain, right? But you don't want any other issue that could fracture the family during that time. And so you definitely want to have everything laid out so that they don't have to worry and think about these things. They'll know exactly what your wishes are. We've given you a lot to chew on. I hope that this conversation has been informative. And again, you can find us online. You can find us on all of our social media channels. On Facebook and Twitter, we are at Elaine Law Group. Our Instagram handle is The Elaine Law Group. It's right over here above me. And feel free to reach out if you need help, and let's stay in touch. Alon?
Yeah, I do want to add one last thing. If you're a husband and wife and you are making your estate plans together, you want to make sure that you have that conversation about what's happening amongst yourselves first. Then, you go into and have your conversation with your attorney. Your attorney may advise multiple things to assist you through your estate planning process. But always make sure that you have an alternative, simply because husbands and wives are often always together, traveling together, vacationing together, and the like. So you always want to have an alternative. And always, if you have minor children, have a guardian set up for those children in the event of the demise of yourself and your spouse, or the entire family. So the other thing that's really, really important, I'm very passionate about, are inherited properties. We call them heirs properties or legacy properties. A lot of our families in the Dallas area are from East Texas, and everybody has some oil property. The problem is we don't think it's a part of our estate, or we don't think that it's important to talk about, because all we're doing is collecting a check. But understand that in the event that your children, your grandchildren don't know about it, or don't go through the probate process in order to be appointed as the executor or the next of kin or whoever, that money is just going to be eaten up by those big, hungry oil companies. So you want to make sure that you are explaining and having these important conversations with your families. The conversation is needed. It's important, and it cannot be a part of a family's legacy if you're not talking about the legacy.
That is so very true, Alon. Thank you so much. And again, that goes to what we talked about earlier. You may not know the nature of your assets even while you're living. There are things that may happen that you're not aware of, things that you've inherited perhaps that from estates, and Alon brought this up earlier, that were not probated. And so the asset may not have been properly passed. And then another life change may happen, and then you basically may have a situation where two estates need to be probated in order to even determine who is to take that property. And so again, these things can be avoided if you have an estate plan and you have outlined to your family how you want things to be handled in your absence. It's very important. And again, it is not too late to sign up for your free legacy checklist. The link is in the chat. So you just sign up. If you sign up, you'll get on our email list. You'll get periodic updates, but you'll also get the free legacy checklist. So you know where to get started. But again, thank you so much for everyone for joining us today. We appreciate the support from the community. Jace Horton said, very helpful information. Thank you. We are happy to serve. Thank you. We're glad we could be of assistance. Elan, any parting thoughts? All righty. Well, thank you everybody again, and we'll see you at the next workshop. Take care. Bye-bye.